repeat that over and over again, but let's jump right into how exactly do you then plan your estate? Estate planning is that process of you arranging whatever assets you have, such that it is properly managed and then easily passed on, either during your lifetime or in this case of sudden incapacitation or death. Now, I know that that word death is something that a lot of us avoid speaking about. There's even a survey I came across, and it talked about how, it randomly asked people, what are the most difficult conversations that you think people have? And the top on that list is death. People have difficult conversations. People find it difficult to discuss issues surrounding death, surrounding sickness, surrounding incapacitation. The second most difficult conversation that people have is on finances, is on money, is on what they have, how they want it used. So you can imagine where the two most difficult conversations, death and finances, what then are we talking about? We should be able to, objectively assess our situation. Now, I've heard people say a lot of times that I'm too young to plan my estate. I'm too young to write a will. I'm too young to have a trust. We don't die early in my family. I'm just 40. I'm just 45. What I tell people is that it's not about your own age per se. It is about the extent of vulnerability of the people that you are leaving behind. And I would like to take that again. It is not about your age in determining whether you are ripe to plan your estate. It is about the extent to which the people that are dependent on you are vulnerable. So if you are 40 and you don't have any single soul dependent on you, you're just very much on your own, you can take that risk and not plan your estate. But I tell you, if you're 40, you're 45, you are 50, you have people who are dependent on you, people who, if you are not available suddenly, their lifestyle would change significantly. Their life trajectory would change, will be altered significantly. If you have such people in your life, then I tell you, you have to plan your estate. So what are some of the tools that we can deploy to plan our estate? You can write a will. I'll go more into details about how that can be done. You can set up a trust, and it can be a living trust. A living trust is a trust that you set up while you are alive, and it begins to take effect. You can also set up what we call a testamentary trust, which is, the combination of a will and a trust. So you write a will, but then in that will, you define that you want a trust to be established, so that your trustees are the ones that will own those assets you're leaving behind and will manage it. You can also, for certain types of assets, you can, execute a power of attorney. You can also incorporate a special purpose vehicle or a non-operating company that can hold assets, not just for you, but for your family. So such that the assets perpetually remain, in the property of that company that you have established. So I will go into details of each of these plans now. So a simple way to plan your estate is to write a will. And what does this entail? A will is a legal document that you as an individual who is above 18, you write, determining what assets you have and how you want those assets distributed and who you want the assets distributed to. So you have documented what you have, who are your beneficiaries, who gets what, in what proportion. It's documented, you sign it, you get two people to witness it, and that will is lodged properly, such that upon demise, the document can be referred to as, your wishes. the parties to a will, you, the writer of the will, is testator, and you must state who your beneficiaries are. There are no ambiguities in writing a will. You must be clear. You also must appoint executors. That means you must appoint persons that you want to oversee how that will is administered. And then, of course, you should have witnesses on standby who will, witness the fact that you signed that will and you did it, with in your full, you did it, with your full senses, and you are in the right frame of mind while you are doing that. So those witnesses will attest to the fact that you signed that will. Another way to, plan your estate, like I mentioned earlier, is to consider establishing a trust. So when you establish a trust, it just means that you are choosing to transfer the legal ownership of what you own, to a trustee, and the trustee will be the ones to, hold that asset, to hold it, manage it on your behalf, distribute it when the time comes, and whatever it is that you desire to be done with those assets, you have a written document between you and your trustee defining what and what should be done. Now, the beauty of a trust is that it can be a living trust. That means that while you're very much alive, you begin to run with it. So it is in place. You have established the trust and you are seeing things happen. So I give an example. You are in your 50s, and you have assets that are in your name. You have some that are in a company name. You can put all of these assets together and put in a trust. But for as long as you're alive, you define that you are the primary beneficiary of that trust. That means that for as long as you're alive, you want to be the one to receive the benefits from all of those assets. So nothing has really changed in terms of the assets that you own. What has simply changed is the ownership of those assets. Let me step back a bit to tell you that the way the law works is that when you have assets in your name, at the point where you pass on, any asset in your name, in quotes, ceases to be yours, of course, because you're no more, but then becomes the property of the government, not property. So the government automatically is holding it in trust for you until when maybe your executors come forward to say, okay, this person who passed has a will, and so we're applying for a grant of probate that you would allow us to properly own this asset that this person has left behind and we want to administer. So what a trust does for you is that rather than you leaving assets in your name, such that upon death, or even in the case of incapacitation where that individual is no longer able to take decisions, is no longer able to function physically or mentally, a trustee is already in place, already managing those assets, has written instructions on what to do upon death or upon incapacitation. So the trustees are able to immediately, set the ball rolling, removing any form of vacuum, removing the need for you to go have to apply, for a grant of probate to the court and all of that. I really hope that you're following me. Please begin to drop your questions in the Q&A box. I am going to make sure that I finish well ahead of time so that we can address some of the questions that you have. So in establishing a trust, three key parties: you, the settlor that is establishing the trust; the trustee can be individuals and it can be corporate. We usually would advise on a corporate trustee because if you appoint individuals as your trustees, the same problem that you want to avoid, which is you as an individual becoming incapacitated or dying, that individual is not immune to that problem as well. But a corporate is a going concern that, the issue of demise does not impact on a corporate. So it's advisable to use a corporate entity as a trustee. And then, of course, your trust should have clearly defined beneficiaries. Who are the people that you want to give your assets to? In what proportion? Over what period of time do you want this to be done? And, all of these things are documented properly in what we call a trust deed, which is, a legal document that is properly executed and defines all of these arrangements. What are those assets that you can put in a trust? Real estate, whether land, whether developed property, cash, whether a cash in the bank or near cash assets such as your fixed deposits, your investments. You can put your equities, that's the shares of companies that you're a shareholder to. You can put such in a trust. Your intellectual property, your digital assets, fixed income instrument, whatever it is, you can put in a trust. And, like I said earlier, putting it in a trust means that you are still very much the owner of those assets. However, legally, the ownership is transferred to the trustees who are holding it on your behalf while you have full unfettered access, to your assets. I had mentioned this earlier, this bit about a testamentary trust. So the beauty of a testamentary trust is that it allows you to combine a will and a trust. So a testamentary trust, in writing, in putting a testamentary trust in place, you are writing a will, and in that will, you are establishing a trust and appointing a trustee to take care of certain assets that you have, such that when you are no more, that instruction kicks in. I don't know if many of us are aware of the late Chief Gani Fawehinmi. That was what he did. He put a testamentary trust in place. He wrote a will and appointed a certain corporate trustee as his trustee to own the assets upon his demise and administer in certain ways. He gave clear instructions how his business should be handled, how the dividends of and the returns from those businesses should be distributed, how the trustee should take care of certain things. So you can, with a testamentary trust, adopt that approach. I'll move on quickly. Like I said, I want to give time for us to be able to take questions and answers. I remember I mentioned earlier that the primary purpose of you planning your estate is to protect the vulnerable people that are dependent on you. And over time, we've observed that the extent of vulnerability varies. So sometimes you have children that are pretty much dependent on you, that are minors, and everything around them, their feeding, their lifestyle, their education, everything depends very much on you. So in some cases, you also have children or even adults who have special needs. And, a concern for a number of people is, while I'm alive, yes, I'm able to, and while I'm fit, I'm physically fit, I'm able to take care of those people that are dependent on me. What happens to them when I'm no more? And that's why one of the things you can consider, is to establish what we call a child protection or special needs trust. A protection trust can be for education, and that means that you are simply trying to ensure that your children's education is uninterrupted at a time, if there comes a time that you become incapacitated or you die. Forgive me, it is very easy for me to refer to death and incapacitation because it is actually a very, very fundamental part of life. We cannot avoid having these conversations. So rather than being afraid of the word death, why not take it upon yourself to plan, for your loved ones, to ensure that if that time comes, you actually do it very light, without any regrets. Well, not that the dead have regrets, but you understand what I mean. So a protection trust can be put in place. It can be as simple as an education trust. You are setting aside amounts of money from time to time to take care of your children's future education at the point where you are still able to set that funds aside, such that in the case of an unforeseen event, the education trust that you put in place, that you have given your trustees instructions on what to do if this and that happens, they can immediately pick it up. And this, I've seen this become very, very useful in families over time. I've seen situations where, someone passed and they have money, or they have assets, but the families cannot immediately access it because either they didn't write a will, or even if you write a will, the process of going through probate can take up to 18, months or more, 24 months or even more, to resolve. And then what happens to the people that are dependent on you for that period that they cannot access your assets? I've seen people's lifestyle change drastically from a comfortable, well-secured lifestyle to a very vulnerable one where they have to depend on family, depend on friends, to step in to even pay, for their school fees. You want to avoid something like this. So if you have minors, you have children who are still in school, you can set up an education trust. You can also put in place a special needs trust. A special needs trust aims at, protecting those adults that have special needs in your life. It can be minors as well. How do you take care of their well-being when you're no more? How do you ensure that the guardians that you are appointing, to take care of them are accountable? How do you fund their needs? How do you fund, the care that they need to have? All of these things can be taken care of with a special needs trust. You remember I also mentioned a special purpose vehicle, which is just simply put, you incorporating an entity to hold assets, for you. Whether you have assets, shares of a family business, or you have real estate, or you have certain things that you do not want to dispose of. You do not want to give instructions, maybe in your will or your trust, to dispose of. You want some sort of continuity with some of those assets. You can incorporate a special purpose vehicle, and put those assets in that special purpose vehicle that the trustees will hold on your behalf, such that your beneficiaries can own those assets through that trust arrangement that you put in place, and then they also can pass it on to, the next generation, still maintaining that same trust arrangement that you put in place. It's also, to some extent, tax efficient, but again, you have to speak with the professionals to guide you on how best to go about this. There are certain types of assets that this fit more into, and there are some situations that would just that this sort of arrangement flow better with. So, in summary, I have listed all of these estate planning tools, and they are not, they have their advantages and disadvantages. So what we want to look at in the, just right about now is to see which one is more suitable for what circumstance or what situation. So if you are considering writing a will, then a will is typically suitable for a family with a simple family tree. I'm sure you understand what I mean by a simple family tree. Father, mother, children. No appendages, no away match that has produced one, no baby mama with a child. And so there's nothing wrong with, if that is your situation, we will come to your own type of family tree shortly. But if your family tree is very simple, you can consider writing a will. If your assets are limited, you can consider writing a will. Now, I'm not saying that a simple family tree, a will always be the best thing to have. We've seen situations where children of the same father and same mother begin to fight and dispute the content of the will that if the father or the mother left behind. So the fact that it is a simple family tree does not also mean that a will be perfect, but this is just speaking generically to each of these tools. When you come to us, the team at EcoBank and Meristem, it's a joint collaboration. When you come to us, we would advise, we would look at your situation, we would ask you questions. The same way you go to a doctor when you have symptoms and the doctor begins to ask questions and you do not hide your symptoms, you do not hide your circumstance from your doctor because you want him to properly diagnose and give you the best care. That's the same way we approach this. We hear you out. What are the assets you have? What is the nature of your family? What are your concerns? What do you want to, what bothers you? If you are not here and you have the opportunity to look at your family from afar, what do you want to see? We ask all of those questions and we are now then able to prefer solution. So for a will, it's a simple process. It can be easily written and concluded, and it can also be amended for as long as you are alive and of a sound mind. You can always amend your will. However, the disadvantage to writing a will is that there are taxes involved at the point of demise when the executors are approaching the court for a grant of probate. They may be paying as much as 10% of the value of the assets that you have. In some states in Nigeria, it is 5%, but in some others, in Lagos, for example, it is 10%. Also, you should know that a will can be contested in court. Now, for living trust, typically when you have a complex family tree, you have multiple wives, you have children from different mothers, or you are in a second marriage, in a third marriage, each of those marriages have children, and you just want to eliminate any form of complexities when it comes to administering your estate. You may want to consider establishing a living trust. Also, if you have beneficiaries that have special needs, like I mentioned earlier, you should consider a living trust. If your assets are well diversified and significant, a living trust is also something you want to consider. The advantages that I had mentioned is that it takes effect while you are alive, unlike a will that only takes effect upon demise. It offers asset protection. So where a trust is properly done and your assets are ring-fenced against bankruptcy, against debtors and all of that. And then, of course, it eliminates ambiguity. So nobody is saying, was our father saying, or was he of a sound mind when he was writing this? No, that conversation doesn't happen because his living trust actually started taking effect before he even passed. So it's difficult to now then come back to say, no, we're contesting this. This is not what he wanted. But he had been executing the wishes in that living trust for a while. So you can't just come up and then begin to fight the execution when he now passes. So that's an advantage. Well, a disadvantage to it is when you consider the transfer into the trust. I don't want to put this as a disadvantage though, because everything is relative. So by the time you compare the cost of probate, which is 10% on the total value of the assets, to the initial cost of transferring of your asset into a trust, it's usually lower. So at the end of the day, a living trust is still a better alternative. I had mentioned testamentary trust, how it allows you to combine a trust and a will. And of course, this does not happen until demise. It's pretty much like a will. It's just that you have appointed trustees and you have established a trust in that will. The probate cost applies to this arrangement, so you wouldn't have escaped the cost of probate. Well, not you, the people you are leaving behind. And then, of course, the special purpose vehicles, like if you have an existing business, a family business, or you have some diverse portfolio and you want to hold these assets in one single entity, you can consider incorporating a special purpose vehicle. It's simple to transfer. The initial cost of, and ensuring legality around that transfer process is also important. But again, relatively, when you look at that cost compared with when you have to go make your beneficiaries go through probate, it becomes relatively easier and cheaper. Of course, it has its demands, because then it's an entity that you have to file statutory returns, you have to, make the necessary filings in line with regulatory requirements. So in rounding up, what are the benefits of estate planning? Like we've said over and over again on this call, it gives you control over how your assets are distributed. I like to put it this way: give what you have to who you want, when you want, how you want it. It is yours. You should be the one to decide on who gets what, and not some random persons or some uncle that believes that they invested in you and they sent you to school, and then they suddenly remember that you owe them, and they are now taking back what you owe, when you've passed, and then leaving that family, to serious crisis. You just avoid all of those family drama. Sometimes I've heard people say things like, no, my family is very peaceful. My siblings and I, they are this and that. I'm sure they will protect my children. I mean, that's our desire, that's the prayer. But I'm sure you also know that people change. Why do you even want to leave it in the hands of those third parties when you have the opportunity to take care of it yourself? Again, I would emphasize your vulnerable dependence. It is not about how old you are or whether you think now is not the time, but just ask yourself, do I have vulnerable dependence in my life that if I am not in a position to take decisions, or I'm unable to, what will happen to these vulnerable people? Whatever your passions, whatever things that you are desirous of, you remember our topic is on you building and preserving your legacy. So sometimes it's not just about the financial assets or assets that you own. Sometimes it's about certain things, certain charitable endeavors, certain passions that you have and you really want to sustain beyond yourself. A number of people have had charitable endeavors that, just ended, closed the moment they passed, and those things that they were doing before they died, just stopped because they are no longer available to do it. You don't want that to happen. So you can actually put together your estate plan. And I would like to, round up by saying this. There's a popular Chinese proverb that talks about the best time to do something. It says that the best time to plant a bamboo tree was 20 years ago, and the second best time is now. So take that decision now. The team is available. They've dropped links in the chat that you can click to get started. We just want to ask you a few questions so that beyond the decision you are taking to actually stop procrastinating, you put pen to paper, you begin to do it now. So feel free, go into the chat room. I'm sure Jemima will speak more to how people can, onboard, how they can reach out to us. The telephone lines, the email addresses are also in the chat room. You can pick those details up and then contact us so that we can have that one-on-one conversation with you. Let's help you to plan your estate. Let's help you, to preserve your legacy. And let's just ensure that you put together everything that is required to ensure that your loved ones are taken care of, whether you are incapacitated, whether you are passing on whatever it is. Give yourself that peace of mind and give the people who are dependent on you the peace of mind that they deserve. Thank you very much. I'll stop here for now.
Thank you very much, Damilola. That was so insightful. I have jotted a lot, and I'm pretty sure the chat room is buzzing with questions. And a lot of people also shared certain steps that they had made. And I'm sure that your presentation has provided more clarity. To everyone in the chat room, kindly note that you can, for more information, there's a link that will be shared there. Just follow the prompts in that link, and then we'll be able to get back to you and answer more questions that you have. If you need more clarity, if you want to get onboarded, we'll be able to sort you out through that link. Just check the chat room and you'll be able to do that. Also, we have questions about people that want to be able to access this presentation afterwards. It's going to be available on EcoBank Nigeria on YouTube. So there's a link also in the chat box. So you can always go to YouTube to gain access to this video afterwards. Now I have a lot of, I've been sieving through questions throughout your entire presentation, and I'm just going to share a few that were top of the list. So someone asked that what could be the shortfalls, if any, or if there are any, if a will or probate process the shortfalls of a will or probate process with respect to the beneficiaries, if there are any, what could they be?
Hope I'm not muted.
No, you're not.
Okay, great. Yes, if I understand that question correctly, the shortfalls to a will and the probate process for beneficiaries, right? Yeah, so number one, the application for a grant of probate will be done by the executors that have been named in that will. And now these executors, they must be people that are available and on ground, because it requires them providing some sort of evidence of the different assets that have been listed. Now, the court is also going to value those assets. I mentioned the 10% probate tax that applies in Lagos, 5% in some other states. So they are going to require that schedule of those assets and work on evaluation. And then they are going to, so if you have assets that of about 100 million comprising of cash in the bank, maybe there's a small property somewhere and all of that, and it adds up to 100 million. 10% of that is the probate tax, and they will have to pay that tax before the grant of probate is issued. So now, one of the shortfalls is they must have that sort of money available to pay before they can access. So what if the assets are not liquid? What if it's just real estate? What if it's shares of companies and they can't access these things before? How do they raise that 10%? That's one shortfall. It also takes time because the system has also been open to a lot of fraudulent activities. So there's a lot of care that is being taken to ensure that it is the right set of people that have brought forward the right document. And this, they have to establish that the will is not fake, that the people bringing it are not fake, so all of that drags the process on and on, such that you're talking of 12, 18 months before they can access this asset. And like I mentioned, what would happen while they are waiting to access? So those are the major shortfalls to writing a will and then it having to go through probate. Thank you.
Thank you very much. I hope that person has gotten clarity with your answer. Another question that is top of mind is, what happens when a will trustee, for example, Meristem, goes bankrupt, ceases to exist due to maybe bankruptcy or liquidation? What happens then in such cases?
Yes. So where the trustees in Nigeria are regulated by the Securities and Exchange Commission, and they have a responsibility to file returns, and the SEC supervises everything that goes on within that industry. There's provision in the trust arrangement for what we call a successor trustee. And we've had situations where trust companies either had to, sell their license or one thing or the other happened, and the provision for successor trustee automatically kicks in, such that the assets that are held in trust by that trustee, don't forget that they are held separately. They are not commingled with the trustee's assets. They are easily passed on to a successor trustee, either a successor trustee that you have named in your trust deed, or a successor trustee that the Securities and Exchange Commission appoints, to take over the role of the trustee. So there's nothing to, the trust deed is a legal document that defines all of these relationships and what redress can be sought if any of such happens in the unlikely event.
Okay, thank you very much, Damilola. Another question is there a threshold of value of assets that can be moved from will to that makes moving it from a will to a living trust appropriate? Is there a threshold of value of assets that can make that appropriate?
Oh, well, so there's nothing defined, but again, you have to look at overall the value of the assets and the fees, because when you put your assets in trust, you will pay fees to the trustees for providing that service. So you would look at it holistically. What sort of fees am I going to be paying relative to the size of the assets that I have? And then do the maths. If the assets are income generating assets, for example, it means that the assets are not idle, and then you can pay your trustees their fees from the income that is being generated. But I would advise that you reach out to the team. The contact details are in the chat room so that we can have one-on-one conversations. It's not a one-size-fits-all per se. Let's speak with you. Let's hear what your circumstance is, and then we can advise accordingly. Let's avoid giving general recommendations.
Awesome. So next question, how can one arrange for an automatic transfer of bank balance to a beneficiary without attracting taxes or probate charges? Is that even possible?
I'll leave Adeola to answer that question.
Okay, let me shoot more to you while Adeola is noting that and prepping an answer for that. So why do banks request for details of next of kin if it's not needed for the estate planning process?
Yeah. So I didn't say it is not needed. The information on the next of kin is very, very vital. It's vital because that's the next person that will be contacted in the case of an emergency. When you go to the hospital and you register, with your hospital, they ask for your next of kin. If there's an emergency, if they need to take a decision, they want to know who is that next in kindred that they can reach out to, that can take a decision on your behalf. So the same thing too with banks. It does not mean that that person is the beneficiary of your assets, so we should not mix that up. That does not give the person legality over your assets when you're no more. So a number of people think that because they've indicated a next of kin, my next of kin is my beneficiary. So I wanted to clarify that your next of kin is not automatically your beneficiary until you put a legal process in place, to define who that beneficiary is. I hope that clarifies.
Absolutely. Another question is, can I change my beneficiaries after creating a trust?
Of course. So for a trust, you can either have what we call a revocable trust or an irrevocable trust. Where your trust is revocable, it means that you can alter whatever it is that you want to from time to time. So you can change beneficiaries. You can add beneficiaries. We've had situations where, clients thought that they were done with having children and they've listed all their beneficiaries. And then a retirement baby shows up at age 49, and then they come to say, okay, I want to add this baby as part of my beneficiary. So you can, with a trust, you can always amend, you can take out persons as your beneficiaries as well. You can define how long you want the trustee to hold those assets and when you want the assets to pass to your beneficiaries. Let me quickly give an example. You know, you may have assets that are significant, and you have children who are relatively young. They may not be minors, but you don't want them to be in charge of all of those assets at once when you pass. You don't want them to come into sudden money, and then the money begins to create confusion and complicate their lives. So we have situations where the trustees, we have a defined guideline from clients to say when each child attains X age, they can have this, they can have that. And then when they meet up with this, and that, which is my own personal requirement, I want my child to have this. So you can, work around all of those things in your trust.
Okay, thank you very much for that response. Another question is, how can one consolidate one's estate, both home and abroad, considering varying national laws?
So I can't answer that on this call because, again, like I said, everybody with their own unique circumstances. Let's please, just if you are the one with that question, just send us an email, or just give us your email to reach out to you, and then we will sit with you and have conversations on how you want to structure. There are various options that you have, and that you can consider in managing assets across various jurisdictions.
Okay, thank you. Please, I hope that person has noted it. Just follow the link, follow the prompts on the link in the chat box. We'll be able to get your information and then provide more clarity for your question. Another question here is the trustee's fee fixed by law? And if so, what is the percentage of the assets, and is it payable upfront and at the point of execution?
Okay, the trustee fees are not fixed by law. So with the arrangement we have, is to allow clients to choose the type of fee structure that they want. So you can either pay a fee that is a percentage of the income that your trust assets are generating, or you pay a fixed retainer fee. So it all depends on the conversations that we have with you, the nature of the assets, that you are putting in trust. If you have assets, if the bulk of your assets are not income generating, then we cannot fix fees that are dependent on the income, for example. So, but again, we can have this detailed conversation. So you can choose what type of fee. There's the only fixed fee is the sign-on fee. So, in you signing up for a trust, we have to sit with you, look through your circumstances, and then advise on the best way to go, and then put that structure in place. So that attracts a sign-on fee that would let you know when you have that conversation with us. But like I said, relatively, when you look at the total cost of doing all of this, it is still way better and cheaper in the short, medium, and long term over, exposing your assets to probate taxes and, the inconvenience that comes with all of that probate process.
Okay, thank you very much. Another question is, can you set up a living trust on your children's education rather than wait for execution of a will?
Absolutely. In fact, that is what we recommend, to even if you have a will and you have children who are still in school, you should have an education trust that caters to their education, such that when you're no more, the trustees already have instructions on school, the nature of the fees and everything, and then they just continue, to pay those fees uninterrupted. So the children don't have to wait, for probate for them to now then access funds to be able to go back to school and stuff like that. They don't have to beg from go to one uncle or auntie to begin to beg. Your spouse is also not under that pressure, you know, to begin to look for funds and all of those things. So you just that education trust just helps you to take out funds and set aside and begin to grow it such that where your children need to access it when you are no more, they can easily access. And if if they finish school and they have no need for it and you're still very much alive, you can of course take back your money. It is yours anyway. So that's an advantage to an education trust.
All right, thank you very much. The questions are dropping. I'm just sieving through. So what are the most common estate planning mistakes to avoid? Like top 5 common estate planning mistakes that we need to avoid.
Not planning your estate at all is a major thing to avoid. Not planning, not having anything in place at all, not speaking to a professional, you know, to understand the nitty-gritty of what it is that you need to do based on your own unique situation. Not speaking to a professional is also a major mistake that people make. Then, you know, assuming that the people you will leave behind know what to do. You know, that has level of assumption is a mistake that people make. They just assume. Some people say, no, I don't want to bother myself. I know I'm going to die before my wife, so my wife would automatically own everything and she'll take care of it. You don't know tomorrow. We've had people say that, and then that supposed wife that is younger passes, and then what happens? You know, we've had people say, no, I'll just give my assets to my children. Let me distribute it while I'm alive. You take house A, you take house B. And then that child marries and then is going through divorce. And then the spouse is saying, this asset is ours, we are split. You know, you have all sorts of funny situations. So please don't make any assumptions about the people you are leaving behind and the extent to which they're able to take decisions when you are not there. Yeah.
Okay, thank you very much. This next
Okay.
question is for This next question is for Adeola. Is EcoBank helping? Adeola, please, you're with us?
I am definitely here.
Okay. So they're asking, is EcoBank helping her customers offset the cost of setting up this estate plan? Is that something EcoBank is doing for their customers?
That is something EcoBank would love to do. We are not currently doing it. And we'll take that feedback and come back with. For us, opportunities are perhaps which is one of the things we're doing here, which is sharing and connecting you with those who can do it. We can also look at how we can leverage our relationship to perhaps reduce that cost for our customers, but we will share that subsequently.
Okay, thank you very much. So ladies and gentlemen in the chat room, please don't forget to use the link for more inquiries. We are available to answer all your questions. Just keep dropping them. There's a team that has been designed to ensure that all your questions get answers. Sadly, we have plenty of time. If we could go on and on, this is a very salient topic. I've learned a lot. I'm sure everybody on this live event, they've also learned a lot. And if we had the time, we would have taken this all day. However, we all have to go back to our different activities for the rest of the day. But this has been a very insightful session. I'm not the one who's going to close this. To close this, I will be calling on the pragmatic and delectable Managing Director of EDC Fund Management Limited. She manages the wealth and asset management arm of the EcoBank Group in Nigeria. She manages the business in Nigeria. None other than Yemisi Ogumola for the closing remarks. Good morning, Yemisi.
Thank you very much, Jemima, and good morning, everyone. Thank you, Damilola, for such an insightful presentation. I currently have a trust, but believe me, I've learned more from this presentation today. From today's discussion, I want to leave you with one thought. The true measure of our success is not just how we plan for our own futures, but in how we ensure that those we care for are cared for, even when we are no longer there. By taking proactive steps now, you're not just making financial decisions, you're crafting a legacy of care and responsibility. Remember, estate planning is a gift to your loved one that provides peace of mind and security in the ever-changing world. Thank you, everyone, for today. Thank you for committing to securing a brighter and more stable future for those you love. Your journey towards financial security does not end here. It's just the beginning. We're wishing you all the best and enjoy the rest of your day. Thank you very much.
Thank you very much, MEC, for that powerful closing remark. Thank you very much, Damilola Hassan, for your presentation. The feedback in the chat box is mind-blowing. I'm definitely just going to go there and peruse all of the comments, and then we'll probably share with you after this session. Thank you so much, Adeola Ogunyemi. I'm sure your feedback has given our customers a bit of peace of mind, as they know that you have their best interest at heart. Ladies and gentlemen, once again, thank you so much for joining us on this live event. We need you to understand that we are dedicated to ensuring that your lives are better, and we will do everything in our power to ensure that we bring you all the information you need to ensure that you achieve that as soon as possible. Once again, thank you. We do not leave you. We will take all your comments. Please, like I said earlier, if you have comments, if you have questions, and if you want us to engage you, just go through the link on the chat box, follow the prompts, and we will get across to you as soon as possible. If you want to experience this live event again, all you have to do is go to YouTube, click on EcoBank Nigeria, and you'll be able to gain access to this webinar. Thank you all for your time. I remain your host, Jemima Ugiagwe. Do have a pleasant day and enjoy your weekend. Cheers.
Thank you, everyone. Thank you for joining.
A new era has begun, shifting our focus to a new horizon, connecting us with one purpose: to create and share opportunities to grow. Today, we are making a brighter tomorrow, built by our dreams and our energy. Across our continent, across the world, we are creating a better way to a better future. An African future, together. EcoBank, a better way, a better Africa. Across Africa, a new era has begun, shifting our focus to a new horizon, connecting us with one purpose: to create and share opportunities to grow. Today, we are making a brighter tomorrow, built by our dreams and our energy. Across our continent, across the world, we are creating a better way to a better future. An African future, together. EcoBank, a better way, a better Africa. Across Africa, a new era has begun, shifting our focus to a new horizon, connecting us with one purpose: to create and share opportunities to grow. Today, we are making a brighter tomorrow, built by our dreams and our energy. Across our continent, across the world, we are creating a better way to a better future. Pan-African future together. EcoBank, a better way, a better Africa.